9. False freedom. In Proverbs chapter 19, verse 5, we have a summation of the 9th Commandment and its necessary enforcement. A false witness shall not be unpunished, and he that speaketh lies shall not escape. The word speaketh can perhaps be translated breathes out. In brief, the law requires, first, the prosecution of a false witness, and second, the prosecution of liars and slanderers. The biblical law with respect to speech is therefore not a declaration of freedom of speech, but a prohibition of false witness in court and of malicious and false statements with respect to men and events in everyday affairs. The distinction is a very important one. The biblical law gives freedom to the truth, not to false witness in its broadest sense. True freedom of speech rests on the prohibition of false witness. At this point, a serious misreading of the U.S. Constitution of 1787 is very prevalent. Amendment 1 reads in part, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press. This has now come to mean the prevalence of federal interpretation in every area of the United States. Originally, it meant that the federal government was barred from any power to legislate with respect to religion, speech, or the press, because these areas were reserved to the citizens and/or the states. The various states had religious establishments and had no desire for a federal religious establishment to govern them. To understand the thinking of Americans on the subject 70 years after the writing of the Constitution, the comments of John Henry Hopkins, Episcopal Bishop of the Diocese of Vermont, are most revealing. The religious right of the citizens of the United States consists in the enjoyment of his own conscientious choice, amongst all the forms of our common Christianity which were in existence at the time when the Constitution was established. This must be taken as the full limit of fair and legal presumption, as the 2 first chapters have sufficiently proved. Therefore, I hold it preposterous to suppose that a band of Hindus could settle in any part of our territories and claim a right, under the Constitution, to set up the public worship of Brahma, Vishnu, or Juggernaut. Equally unconstitutional would it be for the Chinese to introduce the worship of Fo or Buddha in California. Neither could a company of Turks assert a right to establish a mosque for the religion of Muhammad. But there is one case, namely that of the Jews, which forms an apparent exception, although it is in fact supported by the same principle. For the meaning of the Constitution can only be derived from the reasonable intention of the people of the United States. Their language, religion, customs, laws, and modes of thought were all transported from the mother country, and we are bound to believe that whatever was tolerated publicly in England was doubtless meant to be protected here. On this ground, there is no question about the constitutional right of our Jewish fellow citizens, whose synagogues had long before been established in London. But with this single exception, I can find no right for the public exercise of any religious faith under our great federal charter, which does not acknowledge the divine authority of the Christian Bible. Most present-day Americans would not agree with Hopkins, but in 1857 most were in agreement, and there was an extensive legal history supporting their position. The Bill of Rights was then a bill of immunities against federal legislation in certain areas, not a prohibition of state or local legislation. By the 20th century, in America as in Europe, The ideal social order and civil government was believed to be the one which was dedicated to liberty, one which made basic to its purpose freedom of religion, speech, and press. But a society which makes freedom its primary goal will lose it, because it has made not responsibility, but freedom from responsibility its purpose. When freedom is the basic emphasis, it is not responsible speech which is fostered, but irresponsible speech. If freedom of the press is absolutized, libel will be defended finally as a privilege of freedom. And if free speech is absolutized, slander finally becomes a right. Religious liberty becomes the triumph of irreligion. Tyranny and anarchy take over. Freedom of speech, press, and religion all give way to controls, totalitarian controls. The goal must be God's law order, in which alone is true liberty. The law against false witness is basic to true freedom. Today, in the name of free speech and free press, false witness is tolerated, and the laws against slander and libel are progressively eroded. If false religion is right, why not false witness? To exalt freedom over all else, to absolutize liberty, is to deny the distinction between true and false witness. Where freedom is absolutized and made the prior and ultimate consideration as against good and evil, truth and falsity, then Gresham's law becomes operative in that area also. Just as bad money drives out good money, so a lie drives out the truth, pornography drives out good literature, and clean entertainment, and so on. Because of the emphasis on free speech and free press, the United States and other countries have seen the rapid triumph of dishonest advertising and merchandising. The most flagrant kind of evil prevails in these areas, and every attempt to cover them by statute law leads to new avenues of evasion. Neither statute laws nor administrative agencies of civil governments have been able to cope at all effectively with this problem. However, if the criminal law were grounded on biblical law, then every form of false witness could be a criminal offence. Every instance of false merchandising, advertising, and misinterpretation would be a criminal offence. Where false witness is given protection by law in the name of freedom, there a progressive deterioration of quality appears in every area. If free enterprise can be interpreted to mean freedom for dishonest enterprise, for fraudulent goods and merchandising, then the freedom of honest enterprise is diminished. Shoddy goods marketed as quality items tend to drive out, in terms of Gresham's principle, better merchandise which is sold of necessity at a higher price. Because almost all laws against false witness have been gone for some generations, there has been a progressive replacement of honest enterprise with a radically dishonest enterprise. Even the remnants of slander and libel laws require civil action by the offended party, in that the criminal law is mainly unconcerned with false witness. The press, for almost 2 centuries, has been a major threat to freedom rather than an asset to it. The newly gained immunity from statist interference was rapidly interpreted to mean anarchy, and the press has an ugly history of abuse of power. It has consistently borne false witness and defended its right to do so as freedom of the press. A 1970 news report gave a measure of indication of the nature of the problem. There is a growing concern, reported the Sunday Telegraph of London recently, Following 7 months of secret investigations by a subcommittee of the U.S. House of Representatives Interstate and Foreign Commerce Committee, which uncovered evidence of deceptive reporting by American news organizations, national magazines, and their slanted, doctored, and arrogant treatment of the news. The report found that a television team assigned to a student demonstration in California had arrived at the spot with its own picket signs, which it distributed to the demonstrators they were to film. That news organizations have participated in court cases, a fact which Washington terms inexcusable interference with the administration of justice. That the news department of CBS had attempted to finance a commando invasion of Haiti, a definite plan to intrude on the conduct of foreign affairs. The investigative team also uncovered evidence that CBS reportedly staged a pot marijuana party among college students in suburban Chicago. The film of the party appeared later as a legitimate news report to document the widespread use of drugs among upper-class college students and to push for a radical change in the narcotic laws. The Congressional Committee recommended finally, according to the Sunday Telegraph, that a section of the Federal Communication Act prohibiting deceptive practice in television entertainment be extended to make falsification of news a federal offence. The systematic distortion of the news has been reported by newsmen themselves. Whenever freedom is made into the absolute, the result is not freedom, but anarchism. Freedom must be under law, or it is not freedom. The removal of all law does not produce freedom, but rather anarchy and a murderer's paradise. The Marquis de Sade demanded such a word. The liberty he required made a potential victim of all godly men and assured only the freedom for murder, robbery, and sexual violence. Only a law order which holds to the primacy of God's law can bring forth true freedom, freedom for justice, truth, and godly life. Freedom, as an absolute, is simply an assertion of man's, quote, right, end quote, to be his own God. This means a radical denial of God's law order. Freedom, thus, is another name for the claim by man to divinity and autonomy. It means that man becomes his own absolute. The word freedom is thus a pretext used by humanists of every variety, Marxist, Fabian, existentialist, pragmatic, and all others, to disguise man's claim to be his own absolute. Freedom, in itself, means freedom for something in particular. If all men are free to murder, then there is no freedom for godly living. No peace or order is then possible. Men are then no longer free to walk the streets in safety. If men are quote-unquote free to steal without penalty, then there is no freedom for private ownership of property. If men have unrestricted free speech and free press, then there is no freedom for truth, in that no standard is permitted whereby the promulgation or publication of a lie can be judged and punished. False witness is then favoured, and the importance of truth is denied. The commandment of James was this: So speak ye, and so do, as they that shall be judged by the law of liberty. James chapter 2, verse 12. There is a law of liberty. Without law, there is no liberty. The, quote, free speech, end quote, movement at the University of California at Berkeley in the early 1960s was a logical application of the idea of lawless liberty. The students used the public address system to shout obscenities in the name of free speech and to demand the, quote, right, end quote, to copulate openly on the campus like dogs. The students were more logical than their teachers. they insisted on carrying free speech to its logical conclusion, and they recognized the hypocrisy of the liberals who advocated free speech but flinched at practicing it. They were logical too in their sexual demands. If free speech is a valid standard, why not free actions? Their choice of irresponsible freedom was an honest, if wrong one. They pushed the liberal ideal to its logical conclusion. The liberal intellectual objects to any restraint on his absolute standard of freedom on two grounds usually. First, he holds that freedom of speech is more important than any other consideration, and similarly, freedom of press is more important than responsibility. Second, he may agree that pornography is bad, but how can you define it? A student reported that a university professor in class concluded that pornography does not exist because they found themselves unable to define it. This is the rationalistic fallacy that only the rational is real, and the rational includes that which can be precisely and scientifically defined. Instead of life being prior to definition, definition is prior to life. A thing does not exist for the intellectual until he has defined it, until his supposedly creative and defining word calls it into being. It is easy to recognize pornography. It is not as easy to define it. It is easy to recognize a friend, but it is less easy to define what a friend is. Much of reality escapes a definition. Hence the weakness of statute law. Because it insists on defining each particular variety of a crime precisely, it creates a problem for law enforcement. It is not enough for a statute law that a murder or a theft has been committed. A definition by statute must be found and fitted to the crime. And the definition must fit the crime, or the law will not recognize the crime. Biblical law simply states, "Thou shalt not kill" and "Thou shalt not steal," easily recognizable and not in need of definition. Since reality always escapes full definition, the precise definition of crimes by statute means that much criminal activity is not included in the catalogue of crimes.